Welcome everyone to the second edition of Vera's newly revived Neil A. Weiner Research Speaker Series. I'm Aaron Stagoff-Belfort, a program analyst in Vera's Redefining Public Safety program. The speaker series invites distinguished scholars and researchers to share their work on justice issues. The series began under the leadership of the late Neil A. Weiner, a former senior fellow and research director at Vera. In the revival of this series, we are centering researchers who advance race equity through their scholarship in the criminal, legal, or immigration spaces, and when possible, scholars who work alongside and center community members in producing research. A quick few housekeeping notes to start. We have an American Sign Language interpreter for today's event who will be spotlighted along with our speakers. If you have trouble viewing the interpreter or panelists, please go to View Options at the top of your screen. Click View Options and choose Side-by-Side View from the menu. To view the captions, please select the closed caption icon on the bottom of your Zoom screen. Select the arrow next to the closed caption icon. From the list of menu options, choose Show Subtitles. The captions will appear at the bottom of your screen. The last 15 minutes of the discussion today will be saved for Q&A. Please use the Q&A function on Zoom to send in questions. Next, to introduce our three speakers. Amanda Agan is an assistant professor of economics and affiliated professor in the program in criminal justice at Rutgers University, New Brunswick, where she joined in fall 2016. She's also a faculty research fellow at the National Bureau of Economics Research and an affiliate of the Abdul Latif Jameel Poverty Action Lab. Her research focuses on the labor economics and the economics of crime. In Amanda's research, she has analyzed the unintended consequences of criminal justice policies, such as sex offender registrations and ban-the-box laws. Her work has been published in outlets such as the Quarterly Journal of Economics, Criminology and Public Policy, the Journal of Law and Economics, and the Journal of Empirical Legal Studies. Jennifer Doliac is an associate professor of economics at Texas A&M University, director of the Justice Tech Lab, and host of the Probable Causation podcast. She studies the economics of crime and discrimination using causal inference methods to quantify the effects of programs and policies on real-world outcomes. Past and current work addresses topics such as DNA databases, risk assessment algorithms, and the unintended consequences of ban-the-box policies. Professor Doliac's research has been supported by several governmental and philanthropic organizations and published in leading academic journals, including the Review of Economics and Statistics and the American Economic Journal, Applied Economics. She tweets about criminal justice research and policy at Jennifer Doliac. I'll add that she is a prolific tweeter. Anna Harvey is professor of politics, affiliated professor of data science and law, and director of the Public Safety Lab at New York University, and the president-designate of the Social Science Research Council. The Public Safety Lab works with teams of social scientists and data scientists to support more effective and equitable criminal justice practices. The lab's work is supported by Arnold Ventures, the Chan Zuckerberg Initiative, the Pew Charitable Trust, among other donors. The lab's projects include the Jail Data Initiative, a large-scale effort to collect daily individual-level jail records in over 1,000 county jails in the United States, and the Prosecutorial Reform Initiative, a collaborative effort with district attorneys' offices to develop more effective prosecutorial policies. Professor Harvey is the author of 2 scholarly books and a co-authored casebook, in addition to numerous peer-reviewed articles. She's a member of the Board of Trustees of Ohio University. Without further ado, I'll turn it over to Drs. Agan, Doleac, and Harvey for their lecture, Misdemeanor Prosecution.
Hi, everyone. Thank you so much for joining us today. We are honored to be invited to be part of this speaker series. I will basically be doing a brief presentation with slides on some of our recent research on misdemeanor prosecution focused on Suffolk County, Massachusetts. Jen Doleac and Anna Harvey are here with me, and they will help answer questions during the Q&A. And as we always say, they will help answer the hard questions. You can send the easy questions my way. But without further ado, can you see my screen? Maybe one of my co-authors can let me know. Perfect. I will get us into full screen mode and get us started. So we've already had a lovely introduction. I don't need to tell you about who's been doing this research with us. But the research that we're doing here is focused again on misdemeanor prosecution, but really thinking about, across the country in the last couple of years, several prosecutors in several cities have begun implementing policies that reduce or eliminate the prosecution of certain nonviolent misdemeanor crimes. often focused on drug crimes, marijuana possession, and things of that nature, but can often also be broader than that. If we're thinking about district attorneys in Philadelphia with Larry Krasner, in San Francisco, originally with George Gascon, and then Chesa Boudin, George Gascon now in Los Angeles, Rachel Rollins in Boston, and many others across the country that have begun to implement policies such as these. Now, they have received pushback from law enforcement and sometimes members of the community who are concerned about the potential public safety implications of not prosecuting certain low-level crimes. And so it is within this backdrop that we ask kind of our main research question, which is to try to understand what are the public safety impacts of reducing prosecution of nonviolent misdemeanor crimes. Now, on the one hand, we might expect, that if an individual is prosecuted or charged with a nonviolent misdemeanor crime, they might, basically become aware of what the potential consequences are. Those consequences are going to become more salient to them, and they may go on to reduce their future criminal activity, reduce their future criminal legal contact, and this would have the potential deterrent effects that some in law enforcement and elsewhere may hope that these sorts of policies of charging individuals would have. And that's really sort of a broken window style, that if we start by prosecuting individuals for these initial low-level disorderly conduct sort of crimes, that we could actually stop them on a path to potentially more serious criminal activity in the future. On the other hand, we know that criminal records and criminal legal contact have myriad collateral consequences. They reduce access to employment, potentially to housing, to public benefits, and all sorts of, hundreds of these sorts of collateral consequences that can come with having a criminal record. And having reduced access to these sorts of opportunities could potentially increase future criminal activity and thus future criminal legal contact, right? And that damage can work through, law enforcement seeing an additional line on your rap sheet as they go to stop you that may lead to an additional arrest, an additional prosecution, an employer seeing that additional line on your criminal background check who may now be less likely to hire you. And these could, these sorts of impacts could potentially be criminogenic. And one important thing to note is that even non-conviction, so just being charged with a crime, even if that charge is going to eventually be dismissed, those non-convictions add lines to the criminal background checks that employers are going to see. And so even those initial charges can have these sorts of collateral consequences. You don't necessarily need to be convicted to experience these sorts of consequences. And so what we intend to do and what we did in our research was to try to understand what is on average, the net impact of these two potential forces. If we don't prosecute individuals with these sorts of nonviolent misdemeanors, is this going to increase future criminal legal contact for those defendants, or is it going to decrease future criminal legal contact for these particular defendants? And so in order to study this question, we teamed up with an amazing prosecutor in Suffolk County, Massachusetts, Rachel Rollins, and we worked together to collect prosecution records from that office over the last nearly 20 years. These prosecution records from Suffolk County include every criminal complaint that has proceeded into the DA's office, even if the office declined to prosecute those particular charges. And so that's going to be important for us because this is exactly the point in which we want to study what is the impact of declining to prosecute a case. And so if we only had data that had charges that end up in the court system, we wouldn't necessarily be able to see this important initial decision. Right? And so that was why it was very helpful for us to be able to team up with an office that was willing to share this sort of data and try to understand the consequences of the decisions that the office is making. Now, the data is very rich. It includes information on decisions in the case at basically every stage, whether the case or the charge is actually prosecuted, what eventually happens to that particular charge, as well as characteristics of the case and the defendant. What was the type of crime, how many counts were included in the case, and things of that nature. And so this rich data is going to allow us to explore this question of what are the downstream consequences of non-prosecution for nonviolent misdemeanors. And so again, we're really going to be focused on what happens at that very first decision that the DA's office is making. Now, obviously, kind of as a crime moves through the criminal legal system, there's a complicated series of steps that it can take. Now, this schematic that I'm showing you here is not, directly from Suffolk County, but it's kind of a general idea of the sequence of events in the criminal legal system, right? We have a crime, it needs to be reported, somebody needs to be arrested and then booked before it ends up in kind of prosecution, before it ends up in the prosecutor's office. These initial stages are all happening by police or other sorts of law enforcement. And then we're going to be focused on this kind of first initial decision that the prosecutor's office is making on a case that comes into its office from the police. In Suffolk County, this first event, this first decision is known as arraignment. And so that's where we're going to be focusing, is on this initial arraignment decision. We're going to consider a case, we're going to kind of label a case as non-prosecuted if that case is closed on the day of that initial appearance without a conviction. So the individual shows up and basically the district attorney, the assistant district attorney who is working arraignments on that particular day decides not to move forward with charging that case. That case we are going to consider non-prosecuted. A case is prosecuted if basically the defendant pleads guilty right then. So some cases can be convicted on the day of arraignment. Okay, so that case we will consider prosecuted. It has ended in a conviction. Or if the case continues onto any other hearings or anything like that past that arraignment date. Now, that case may eventually be dismissed at a subsequent hearing. That case was still prosecuted, right? The prosecutor's office moved forward with charging the case, even if it was eventually dismissed. So it's not that every case that is prosecuted is going to end up in a conviction. It's just about whether the case actually moves forward past that initial arraignment decision. And that's going to be the decision node that we are focusing on. When a prosecutor or an ADA chooses not to prosecute that case, what's going to happen to the downstream consequences for that particular defendant? Of note, in Suffolk County, and within the sample that we are focusing on, 21% of nonviolent misdemeanors that come into the office, an ADA declines to prosecute that case. Those cases are non-prosecuted. So we'll see nearly 20% of those cases non-prosecuted, and we'll try to compare those against the nearly 80% of cases that move forward with some form of prosecution. Now, how are we going to do this? How can we think about estimating the impacts of non-prosecution on future criminal legal contact? Now, we could try to simply compare outcomes for the 21% of cases that are non-prosecuted and the 79% of cases that are prosecuted and see what does future criminal legal contact look like for those two groups of defendants. Now, when we do that, here we're seeing for the 21% of cases that are not prosecuted versus the 79% of cases that are prosecuted, across various definitions of future criminal legal contact within the next 2 years. Let's focus first just on this first line. Do you have another criminal complaint in Suffolk County in the subsequent 2 years? Think of a criminal complaint as basically a future arrest, a future case that's showing up in the DA's office. Individuals or cases that are not prosecuted are much less likely to end up with defendants who have a criminal complaint within 2 years versus those that were prosecuted. A decline of nearly 41%, right? A very large decline when we're looking at this. If we look at a new prosecution within 2 years, so not just a complaint, but actually getting charged with that subsequent crime, a similarly large decline. Another interesting outcome that we can look at here is whether the defendant ends up with basically a new record in the official criminal record that Massachusetts holds. So Massachusetts's criminal record information, CORI, is held by DCGIS, and those DCGIS records are basically what employers are going to be searching, other prosecutors are going to be searching, future law enforcement are going to be searching. And so one thing that we can look at is whether this defendant just ends up with a new line in that DCGIS record. And that also significantly declines. I'm going to talk about that outcome a lot more when we start thinking about some of the mechanisms behind some of the results that I'm going to show you as well, because it's going to give us sort of some interesting motivation for some of what we're seeing. But if we were to just compare these sorts of prosecuted cases to the non-prosecuted cases, we would see significant declines in future criminal legal contact for cases that are not prosecuted. So maybe we could end our story there. But as you can imagine, cases which assistant district attorneys at that moment of arraignment decide to prosecute are just different along many dimensions than cases that the ADAs choose not to prosecute. And in fact, we can show that by looking within our sample. Again, these are our nearly 80% of prosecuted cases versus our 21% of not prosecuted cases. And here we can see that cases that the assistant district attorneys, the ADAs, choose not to prosecute are less likely to have had a conviction, either misdemeanor or felony, in the previous year. They have fewer counts associated with their cases. They are more likely to be citizens. They are more likely to be charged with what we might think of as a victimless crime, drug crimes, certain sort of disorderly conduct crimes, right? And so these cases are just different. And if we just take these dimensions at face value, they're the sort of characteristics that might be associated with the sort of case or defendant that might be less likely to recidivate in the future, right? Doesn't have as likely of having a recent previous conviction, right? Then you might think they might be less likely already to end up with criminal legal contact in the future. And so it's hard, given these differences across these two types of cases, to look at the fact that the not prosecuted cases are less likely to recidivate and say, well, is that really because they were not prosecuted, or is it because of these different case characteristics? And so how can we think about estimating causal impacts in this environment? How can we truly understand what was the causal impact of not prosecuting that case on future outcomes, as opposed to the impact of these sorts of compositional differences of the two types of cases? Now, if we were in science, in the hard sciences in particular, but in the social sciences as well, we might immediately think to randomization as sort of the gold standard for trying to understand what are the causal impacts of a particular policy. In that case, we might think of randomly flipping a coin. Some defendants, if you get heads, you're prosecuted. If you get tails, you're non-prosecuted. Well, that would certainly solve one problem, right? That would balance out the case characteristics across the prosecuted and non-prosecuted cases. It's going to cause a myriad of other problems, right? There are clearly very obvious ethical and legal objections to that sort of randomization. We're never going to actually perform that sort of randomized control trial on actual defendants. But it's kind of a baseline that we can think of, what if we could find something that sort of looks like that already? And that's what we actually have in Suffolk County, right? So within a courthouse, so Suffolk County is made up of several courthouses, right? There's courthouse Dorchester, Chelsea, and Boston Central. There's multiple courthouses within Suffolk County. Within a courthouse, there are many ADAs that are working in that particular courthouse across different courtrooms, where some of those courtrooms are going to be focused on arraignments, those individuals who have recently been brought in on a criminal charge. Then there'll be other courtrooms that are focused on preliminary hearings or trials or other aspects of that sort of criminal legal process. And so we know that within Suffolk County, those ADAs are going to rotate into those arraignment courtrooms. Okay, so for some weeks or for some days, they're going to be assigned to go into that courtroom and make decisions on any arraignments that happen to come in on that particular day. Within our data, we see 315 ADAs making decisions on arraignments between 2004 and 2018. And on average, those 315 ADAs are making decisions on arraignments across 83 days, dispersed over about 3.5 years. And on average, those ADAs are seeing nearly 214 arraignments. Okay, and so we see them kind of rotating through these arraignment courtrooms. And importantly, the nonviolent misdemeanor complaints that are coming into the arraignment courtrooms, they're assigned there without any regard to identity of the arraigning ADA, right? No defense attorney, no individual defendant gets to say, no, wait a second, Anna is working in that courtroom today. I don't want her. I want to move to a different courtroom or a different day, right? There's basically no room for manipulation in terms of which ADA is going to be hearing your particular case on the day that they happen to be assigned to that courtroom. And so it is as if cases are randomly assigned to these ADAs. It may not be a literal bingo ball process, but it's going to mimic the sort of characteristic that we want out of randomization. That is, it's going to make sure that the set of cases that ADAs see in terms of making arraignment decisions are all very similar across these ADAs. Certain ADAs aren't all getting the very hard cases or aren't all getting the very easy cases, or whatever it is. They're going to see basically a very similar mix of cases. And importantly for us, what we see in Suffolk County, and what we see actually in a lot of the criminal justice space where individual actors are making discretionary decisions, like judges making decisions on sentencing, is these ADAs are going to vary in the likelihood of not prosecuting the average nonviolent misdemeanor case that comes in front of them. Now remember, and I'm going to show you a little bit of evidence of this in just about 2 minutes, but we just argued to you that these cases are basically randomly assigned to an ADA. So the ADAs are all seeing very similar bundles of cases, but they vary in the likelihood of not prosecuting that bundle of cases. So we told you already that the average leniency, the average non-prosecution rate was about 21%. But we have ADAs that choose not to prosecute nearly 50% of the cases that come in front of them, whereas we also have ADAs that choose not to prosecute somewhere around 5% of the cases that come in front of them, right? And we're seeing here just basically that distribution of that leniency, of that choice, that average non-prosecution rate across the cases that those ADAs are seeing. And it varies significantly from ADA to ADA. Right? And that's going to be really useful for us in terms of trying to understand what the impact of non-prosecution is on defendant outcomes. I also argued to you that these ADAs are basically randomly assigned to cases. And of course, what we liked about the idea of random assignment was that those case bundles would be the same across ADAs, right? We would no longer have this problem that, non-prosecuted cases are very different from prosecuted cases. That would still be true. But the ones that are assigned to a really high leniency ADA versus a really low leniency ADA, those are basically going to be the same if we had random assignment, which we can actually see in our data as well, even though we don't have some sort of literal bingo ball assigning a case to an individual ADA. Here we've literally just broken up the data into low leniency ADAs, those that are below the median leniency rate in our data, and high leniency ADAs, those that are above the median leniency rate in our particular sample. And we see that they're seeing nearly identical types of cases, right? 8.5% of those assigned to low leniency ADAs have a misdemeanor conviction 1 year prior. 8.6% of those assigned to high leniency ADAs have a misdemeanor conviction 1 year prior. And this is similar across all sorts of case characteristics and defendant characteristics that we can measure in our sample, which makes us more confident, in addition to what we already know about the assignment, that this assignment was basically random, and that we can leverage this then. We can use this as if random assignment to a less or more lenient arraigning ADA as a natural experiment, not one that we forced on anybody, but one that the policies of the office was already creating as an opportunity, basically, to study our particular question with some random assignment. Some defendants get lucky and they get a lenient ADA. Some are unlucky and get a harsher ADA. And for some defendants, this is actually going to impact whether their case is ultimately prosecuted. Clearly, there are some defendants who walk in and their cases are going to be prosecuted no matter which ADA they end up seeing. The strength of the evidence or what have you is just strong enough that makes it so they're always going to be prosecuted no matter who we see. There are some cases that are going to walk in the door that are obvious non-prosecutes. Everybody's going to drop those charges, no matter what their leniency rate is. And it's those cases sort of in between where it matters whether you happen to get assigned to a high leniency or happen to get assigned to a low leniency ADA that are basically going to be the focus of our analysis. We call these cases marginal cases, okay? And our analysis is going to uncover what is the impact of non-prosecution for these marginal cases, the one for which getting assigned to a relatively more or less lenient ADA is actually going to impact outcomes. Now, obviously, we can't actually see this sort of counterfactual outcome, what would have happened if you got assigned to a different ADA, but our statistical techniques are going to allow us to uncover what this impact is for the marginal defendants. I also want to be clear that although on the previous slide, we broke things up into above median leniency and below median leniency in terms of that sort of ADA leniency, that we are not going to do that in our actual analysis. Our actual analysis will be focused on the full distribution of ADA leniency rates. So what do we find when we do this? We're going to put together our results using an instrumental variables design, if you're familiar with that. If not, don't worry, but we're basically leveraging that random assignment, again, to try to understand the impacts of non-prosecution for these marginal defendants. So what do we find? For these marginal cases, not prosecuting a non-violent misdemeanor case significantly reduces the probability that that defendant ends up with a new criminal complaint within 2 years, and this reduction is large. Is nearly 58% over similar defendants who are prosecuted. It's similarly going to reduce the number of new criminal complaints within 2 years, the number of new misdemeanor complaints, and the number of new felony complaints. We can see this if we look within 3 years, and we see suggestive evidence that it's also reducing within 1 year as well. Although we'll focus most of our analysis here on 2 years, we have exact dates of what's happening to these individual defendants in the future. And so we can map out what these impacts look like 3 months after the case is not prosecuted or prosecuted, 3 months after that arraignment decision, 6 months, 9 months, 12 months, 15, all the way up to 3 years after that initial arraignment decision. And we see that this effect, if anything, is actually increasing over time. This beneficial effect of reducing the probability that an individual ends up with future criminal legal contact is, if anything, increasing over a 3-year horizon after the arraignment decision is made. So if we put this the other way, right, that implies that prosecuting defendants for these marginal nonviolent misdemeanor cases is actually increasing the probability that they end up with future criminal legal contact, increasing recidivism as we may be measuring it here. So what's going on? Right? There are several mechanisms by which we might think that non-prosecution may actually reduce the probability of future criminal legal contact. Right? And we talked about some of those early on in the presentation. Right? We may think that non-prosecution is likely to prevent or reduce the probability an individual gets that additional mark on their criminal record. Right? This would thus reduce the collateral consequences of that criminal legal contact and help potentially increase opportunity for that individual. It's also going to reduce the amount of time that an individual is tied up in criminal legal proceedings, right? Having to attend hearings on dates that you don't get to decide, potentially having to miss work or miss out on work opportunities. And obviously, if you're not prosecuted, then you're not going to end up convicted, right? End up with that conviction mark on your record and any of the potential punishments that come with that conviction. Now, this is not necessarily an exhaustive list of the potential mechanisms behind the impacts that we're seeing, but it is a list of the mechanisms that we can try to measure. And so we actually do see all of these things taking place. So non-prosecution is significantly reducing the probability that that DCGIS record, that formal database that is housing the criminal records for individuals in Massachusetts, is seeing any information about that particular criminal complaint. Now, it doesn't go down by 100%. This just the kind of context that we're working in Massachusetts. there's a particular time, there's a particular event that happens at arraignment, after which that event, that criminal complaint will end up in the decisus record. If the charge is dismissed before that particular event on that particular day, then we won't end up with the decisus record. So some of our cases that are non-prosecuted will end up with the decisus record, but you reduce the probability of having that additional line on your criminal record by nearly 56% by avoiding prosecution. It clearly is going to reduce the amount of time that you're tied up in criminal proceedings. The average prosecuted case in our sample, so if you do move forward with prosecution, that case remains open for nearly 185 days on average. So on average, you're tied up for a large portion of the year and potentially losing out on work opportunities, having that pending case on your record. And 26% of the prosecuted nonviolent misdemeanor cases in our sample do result in a conviction. So first, to be clear, that the counterfactual here involves a lot of dismissals, right? We're mainly talking about non-prosecution versus being prosecuted and dismissed, right? But still, about a quarter of those prosecuted cases will end up with a conviction, and the non-prosecution clearly allows you to avoid that conviction and the potential punishment consequences that may come with that conviction. Now, what we've talked about so far is thinking about these sort of marginal cases, what's going on with these marginal cases, the ones that being assigned to a more or less lenient ADA is actually going to impact outcomes for those particular individuals. What does non-prosecution do? And so, how do these findings then speak to the policies that I brought up at the very beginning that progressive prosecutors across the country are beginning to implement, of establishing presumptions of non-prosecution, at least for certain low-level misdemeanor crimes? What can we say about those sorts of policies? Now, we think already that our results are promising, that those particular presumptions of non-prosecution are not necessarily going to be exacerbating public safety problems, right? But we can actually go a step further. And so we are able to see, in our data, we can estimate the impacts of the inauguration of Rachel Rollins on non-prosecution and subsequent criminal complaints within 1 year. So Rachel Rollins, one of these sorts of progressive prosecutors, an amazing one, was inaugurated on January 2nd, 2019, and she ran on a platform that included a presumption of non-prosecution for a relatively large set of non-violent misdemeanor crimes. Okay, and so, she's inaugurated January 2nd, 2019, right? I think we all know it happened around March 2020. The world kind of changed then. So we're going to be looking at a shorter term of thinking about future criminal legal contact here. Our previous analysis focused a lot on this sort of 2-year window. We're going to focus here on a shorter window and a 1-year window, and look at what happened within that 1-year window to subsequent criminal complaints, after first showing that her inauguration actually did increase non-prosecution for non-violent misdemeanor crimes. So we do find that after her inauguration, January 2nd, 2019, that non-prosecution rates rose nearly 20% for non-violent misdemeanor cases. So we see this large expansion of non-prosecution after she is inaugurated. And yet, for these cases, we still find reductions, at least suggestively, in new criminal complaints within 1 year that are of a similar magnitude to our main results, right? We see no evidence that this broad expansion of non-prosecution amongst these non-violent misdemeanor crimes was somehow increasing recidivism when we expanded beyond what we were looking at in the past. And if anything, it was still reducing the probability that those defendants ended up with new criminal complaints within 1 year. Now, the other thing that law enforcement or other detractors might have been concerned about in terms of implementing a presumption of non-prosecution was that by doing so, we might increase crime levels generally, not just thinking about recidivism for individual defendants, but that once the public knew that there was going to be non-prosecution for these particular crimes, that we might see increasing reports of these sorts of non-violent misdemeanor crimes. And so we look also at reported crime rates in Suffolk County, Massachusetts, both before and after. Here now our dashed red line is representing just basically the moment that Rachel Rollins gets inaugurated, what's happening to reported crimes amongst these sorts of property damage, disorder, drug, other sorts of misdemeanor crimes, that the sorts of crimes that they would have been non-prosecuting. And here, just at least visually, we see no evidence of some large increase in reported crimes after her inauguration and after these non-prosecution rates for these crimes increased significantly. And so I think altogether, right, our evidence suggests that reducing prosecutions of marginal nonviolent misdemeanor defendants reduces future criminal legal system conduct. And our evidence also suggests that a policy of presumptive non-prosecution for certain categories of nonviolent misdemeanor offenses reduces future criminal legal conduct with no short-term increases in reported crime. Now, we are very interested in expanding this analysis beyond Suffolk County into different time periods or different jurisdictions. We are starting to work with several DA's offices in order to expand this analysis and see what results look like if we're looking in different jurisdictions, in different contexts, and in different time periods. And so we look forward to hopefully having those results sometime in the future. But for now, that's what I had to say. We look forward to your questions and to your feedback.
Thanks so much, Dr. Agan. I'm going to turn it over to Saliki Flingai, a research associate with our Reshaping Prosecution team, who will be moderating the Q&A.
Hi, this is Saliki Flingai. Thanks, Aaron, for the intro. And again, thank you, Professors Agan, Doliac, and Harvey for this amazing work. I know we are not on video, but I just want to probably for the Vera researchers clap and thank you for presenting this work. And so, yeah, the work that you presented today speaks to and confirms to a large scale things that we often hear in our work on reshaping prosecution from community members, which is that shrinking the reach of the criminal legal system, including the prosecutor's office, can have a net positive on community safety. And one quote that I keep returning to from your original paper that has stuck with me is that we may in fact be undermining public safety by criminalizing relatively minor forms of misbehavior. I thought that was a really succinct, beautiful summary of what this work kind of speaks to. So it's truly a pleasure to hear from you and to engage with this work. And for the audience, if you have any additional questions that you'd like to have this author speak to, please don't hesitate to use the Q&A. The question that immediately came to mind for me, that is also actually the first question I received in the Q&A, coincidentally, I think speaks to this question about public safety and where your work kind of sits in that space. All right, so it seems like we can't go a day without hearing from the media or from law enforcement in some way, shape, or form about rising crime, and they frame the stories that kind of dictate how we as people in the communities think about crime in our areas in a lot of ways, right? So I think that the media is not the only player in this world of rhetorical and narrative shaping. And so I'm very curious kind of where you see this work in that conversation. And as researchers, how do you communicate your work post-publication to help inform this narrative shaping and this rhetorical battleground that's so often dominated by racializing or otherizing people for carceral ends? So we'll start there. I'm sure each of these questions that I received will actually take like 30 minutes to answer each, but best of luck.
Well, this is a great question. I'm going to throw this one, put Jen on the spot because she is our publicity machine. And if we're talking about how we kind of publicize our results and thinking about speaking to this conversation, I think she's going to have our best answer.
And Amanda is surely tired of talking. Sure. So it's a great question. I think all three of us in the, the general along, some spectrum of academic researchers, we're on the end of really caring about making sure our research has a policy impact and that the findings get out into the world. And so, we're doing lots of events like this, taking lots of calls with DA's offices, I know that Anna, in her new role as the SSRC president, is starting to have conversations with police departments about, bringing researchers to talk directly with chiefs of police and others who are working in that space to make sure that they're aware of the latest research. Our own and other complementary research has come out lately, really showing that police have a really important role to play in communities, but when they target these lower level offenses, it seems less valuable. And so really trying to make sure that these results don't just stay locked up in academic journals, but getting them out into the world, writing op-eds, talking to policymakers directly, and basically talking to anyone who will listen. We're on a lot of phone calls these days. So when groups like Vera reach out, we say yes, and are happy to do more of that. If others on the call have groups that they would like us to be talking to, we're all ears.
Great, thanks for that. And I think another part of the kind of rhetorical conversation that I think this work also speaks to, and listening to you describe the work in podcasts and other media, y'all have been thinking about this as well. But there's a focus on nonviolent crimes in this report. And so do you feel that this focus on nonviolent misdemeanors, which more palatable and sympathetic to many people in the public, how do you view its potential limits on the far-reaching reforms that do not take the criminal legal system as it stands, or DA's office's roles and the power that they have as a given? And so another question that was attached to this is that also wondering how you think about the fact that the prevention of future crime may not actually be the goal of arrest and prosecution. So thinking about, criminal legal system as a social control mechanism or other types of things of that sort, how do you think this focus on nonviolent crimes, but also this focus on preventing future crimes speaks to that as well?
So it's a great question. And I think that there are so many pieces of it that I want to pick up on. So I'll start with the easy one, and then maybe hopefully myself and my collaborators can speak to some of the larger questions as well. And the first is just to say, in some sense, the focus on nonviolent misdemeanors was, one, to speak to what's happening in policy, but also because of the empirical context in which we were working. It is those nonviolent misdemeanors that have that characteristic that really allowed us to try to understand and tease apart what the causal impact of non-prosecutions were. The kind of assignment mechanisms that we were speaking to don't necessarily happen with violent crimes, even violent misdemeanors, or other types of felonies. And so part of it was, a true desire to focus on a causal impact, and that's where we could find one. But at the same time, that makes it so our work is, speaking to nonviolent misdemeanors in particular, and not necessarily to a potentially broader conversation that we could be having about major reforms to our criminal legal system, and where this line should be about what should be considered criminal, what should be prosecuted, what should the roles of police and prosecutors do. We think of this as one piece of that puzzle, and one step toward that understanding, but that a lot more work hopefully will be and needs to be done. But I want to let my collaborators speak to some of the bigger questions as well.
I mean, I'll just jump in and say that there's a great paper by Michael Mueller-Smith and Kevin Schnapel on felony charges in Texas, showing that, very similar finding before our finding, it's actually coming out in a journal now, that diverting first-time felony charges to deferred adjudication with then dismissal of charges has a very significant impact on later rearrest and also employment prospects in the same direction as our findings. So there is that. And we, in talking with district attorneys' offices, are looking for opportunities to expand the set of charges precisely for the reasons that you mentioned. We just need to be able to leverage that as if randomness, which is harder if charges are more serious, if they involve firearms or they're felony or there's some kind of, violence oftentimes more senior prosecutors are called in to consult on the case, and so we lose some of the as of randomness. It's a great question about what exactly is the goal of making arrests and prosecutions, right? And certainly, you see people saying that, well, geez, it's the law. If you break the law, you need to be arrested and charged and prosecuted. And so I really think it's a question for communities to consider the trade-offs. Like, you may have some sense of, necessary retribution, or, call that justice, but you need to understand that pursuing those choices will have consequences down the road for safety in your community. And, communities can choose what kind of balance they want. But I think we want our work to highlight at least some of the consequences of pursuing those arrests and prosecutions, and deciding whether is that really what you want as a community.
Yeah, I'll just piggyback off that a little bit. I mean, so Amanda and I are trained as economists, and it's common in econ circles to say, you tell me what your objective function is or what you care about, and I'll tell you what you should do. But I'm not here to tell you, what that objective function should be, or how you should be weighting the different things you're considering. And so I think this, the set of results we're showing is relevant if future impacts on public safety are of concern in these conversations. Like, if that's part of the reason that we bring someone to court and try them for a crime and perhaps punish them. And I think it is. I think, we try, at least most of the time, I think most people think that there's some deterrent effect or some incapacitation effect that comes from, pulling people through the criminal justice system. But there are a lot of people who do, as Anna said, care about retribution, right? You did something wrong, and so you should face the consequences. And if that's a big piece of the reason that that communities want to really crack down on these low-level crimes, then maybe our results are not relevant to them, or less relevant. And so, so I think, the types of results that we're showing, we hope inform those conversations. And to the extent that that people do care about public safety, which again, I think they do, we hope that they take this into consideration, or at least, again, I guess another way of putting it is, if part of the reason that people might be reluctant to treat low-level offenses more leniently is that they're concerned that crime's going to go up and actually recidivism is going to go up, then hopefully our paper kind of reduces those concerns a bit, right? Like, we're finding that if anything, it's the opposite. You can actually be more lenient when it comes to those more minor offenses, and actually you're going to get public safety returns from it. So it's not a trade-off in the way that I think a lot of people might think it is initially.
I think one thing that that speaks to is, I think to a degree, like the language that people use, but also the behavior of the stakeholders in the system. One question that's come up is how this work, or whether you've seen this work kind of influence police behavior in terms of how they arrest, or also whether it influences prosecutor morale or prosecutor kind of job satisfaction. These things that kind of question their role in the system. So I want to combine those two questions and see if you have any thoughts on those.
Know that maybe you guys have seen reactions from police. I think most of the conversations that we've had have been with prosecutors, and in a lot of prosecutors in the sort of offices that are starting to implement these sorts of policies. And so for those sorts of offices, this result is key. This result is very helpful in terms of potentially expanding on these sorts of leniency policies. But I don't think that I have heard reactions from police in terms of changing behavior and charging behavior in response to these sorts of, potentially in these sorts of policies, but into our research in particular. I think we saw evidence of a little bit of pushback in Massachusetts from one prosecutor's office writing kind of a letter to a newspaper, saying that kind of contra our results, and I think we've seen a little bit of that, but not so much. But I don't know if you guys have had some different experiences.
You can see in some jurisdictions changes in the arrest rate after, or like the volume of arrests, I should say, after New York City, as the different boroughs started to implement declination policies for things like theft of services, fair beating, or possession of, you could see arrests for those go down because in those cases, the policies were very clear, like we're just not going to prosecute. It's we don't see very much of that in Suffolk County. And remember that Rachel's policy was more about it's a presumption of non-prosecution. It doesn't actually, the non-prosecution rate for these offenses only goes up like 5 percentage points relative to the baseline. And so a lot of these cases do in fact still get prosecuted. But yeah, you do see some changes in arrest behavior, which actually kind of complicates the the analysis of it. We don't have that particular problem in our context, but you might see it in other contexts.
So that kind of speaks to the strength of the policy impacting the potential kind of downstream effects. If it's a clear declination policy versus if it's a presumption of declination, that can have different possible outcomes on the behavior of downstream actors.
Yeah, it's definitely possible, and something that we're hoping to study as we expand this sort of research agenda to different areas and different jurisdictions.
Yeah, I was just going to say, I think a lot of these questions really are still research frontier, right? Like even the question of what the long-term effects of these types of policies will be in any jurisdiction. I think we're curious to see if the effect even in Suffolk County changes over time. There is, I do talk to people who are worried, even if, the immediate effect on people who are now not prosecuted, their recidivism goes down, and maybe there's no short-term effect on general crime. But if you essentially, put out a blanket policy saying you're very unlikely to be prosecuted for shoplifting, I would expect, that's an economic crime. I would expect you're potentially incentivizing people to go out and take whatever they want from CVS. And I could imagine, I can imagine that's plausible that would happen and that effect could grow over time. And so I think we're very curious to just keep an eye on the data and see what the data say and track this in a lot of different jurisdictions to kind of help jurisdictions figure out the right balance here.
Just quickly on this point, it's also the case that, and this is why it's going to be really interesting to potentially also expand our work to include police departments. There's also work suggesting that arrests, right, do not have a deterrent effect on crime, and so it's kind of like I agree with Jen. I think it's kind of plausible both ways, and we don't really know what will happen. And so, there's a group of us, we are visiting the Major City Chiefs Conference in September to present this work, along with some other work, including the work suggesting that arrests for these, not just prosecutions, but arrests for these low-level offenses aren't decreasing crime, and to potentially see if there are policing agencies that are interested in working with researchers to experiment with implementing alternative strategies to these mass enforcement strategies.
And just to highlight one more thing, because I think all of us internally, we do talk about how important the role that police have, and of course, there's plenty of evidence that police presence reduces crime too. But I think just to highlight again, like the impact that police seem to have really is on these more serious offenses, right? Or putting more police on the streets can reduce homicide rates, but at this potential cost of maybe, increasing low-level arrests. But those low-level arrests don't seem to be actually the mechanism for why they're reducing the more serious offenses. And I think both in conversations with the DA's office, but I suspect also these future conversations with police departments, I expect that a lot of the conversation will be about, we want to help you shift your resources to the places where you can actually have the biggest impact. And I know that's something that DA Rollins has talked about in Suffolk County. Like, she doesn't want her DAs and her office to be spending all this time dealing with low-level trespassing charges. She wants to be going after people who are there for robbery and homicide and things that are actually really affecting public safety in her community. And I imagine that's what most police departments want, or most police officers want too, right? And it's just a question of like, how do we get there? How do we actually use resources in the most efficient way to achieve more public safety? And the punchline seems to be, stop arresting people for this low-level stuff.
Thanks for that. We only have 5 minutes left, so I want to combine a couple of general questions that people have asked. Maybe I can have one person speak to one of the questions, and the last question, which I think everyone can speak to. So one person asked, to what extent have you engage with directly impacted community members during the process and or afterwards. And so maybe you could have one person speak on that. And then lastly, there's a lot of questions about the generalizability of this work. We know that you're going to many different sites and working with many different partners, but I just wanted to get your thoughts on how you see these results being generalizable, or if you think these are particularities in Suffolk County that speak to this result. And yeah, so.
Just on the community the impacted populations question, we did early on in our work with Suffolk County, we met with the ACLU's racial justice program in Massachusetts, and they were kind of an early part of our work in trying to figure out, like, what are we going to do with this data? What kind of questions are we going to ask? I'm really excited that just, I think last week we submitted a grant proposal for the three of us to continue this work with other offices. And in that proposal, we included a request for subgrants specifically for community organizations in Baltimore and Boston, Georgia, and Brooklyn, who are working with individuals who are justice involved, and to kind of help them, again, sort of shape our thinking and inform mechanisms. And so I think I look forward to kind of to doing more of that work if we can get support for it.
And I think that directly then speaks to the issue of generalizability in many ways, that we do think that this is promising to implying that that general policies of non-prosecution are not going to be exacerbating any kind of public safety issues or making public safety worse. But as researchers, we want to say, like, there's a caveat to that. We did only study this in Suffolk County in this time period. And I really think it is going to take some more research across jurisdictions in order to really understand whether these are truly general results or whether they were very specific to the time period and the context. And that's why we're excited about this grant and these kind of future collaborations that we'll have across contexts. And so we hope to have a better answer for that soon, but we think it's a promising first step. And at least we're not seeing the world fall apart in Suffolk County when you don't prosecute these sorts of crimes. So, and we don't really expect the world to fall apart elsewhere. But we'll look forward to seeing the data speak to that question.
Yeah, and I think just a little bit more on the generalizability. Like, I think this question of where the line is too is one that we've been thinking a lot about as researchers. Like, should we, our results say that at least in Suffolk County, and I think we have good reason to think that those results should generalize to other similar offices, at least, erring on the side of leniency for especially first-time nonviolent misdemeanor defendants can have some real public safety payoffs. But as has come up in some of the questions, like, what about violent misdemeanors? What about gun charges? What about domestic violence? There's this Mueller, Smith, and Schneppel paper that looks at deferred adjudications, where you get put on sort of a probationary period for a nonviolent felony. Do they need the probationary period to really have the impact that can have? There's sort of all these additional questions about, I think, in general, what these results are saying is we should be erring towards second chances and erring toward more leniency, starting from a place where we, as a country, have just, we heavily penalize all kinds of behavior. And so starting to roll that back, I think, will be a long-term process, and figuring out kind of like what the optimal level is or where to really draw the line. Presumably it's somewhere below murder, but somewhere above disorderly conduct. And like, there's a whole bunch of stuff in there. And so working with these other offices to really help them work through what the trade-offs are in their communities, and just get the data and see what works, I think is something we're all really excited about.
Thanks. Well, we're looking forward to all the future studies. Thanks for the sneak previews on the policing one too. I'm super interested in the arrest one as well. So just want to thank you again, all three of y'all, for the amazing Q&A, the amazing presentation. I'll pass it to Jakia for closing.
Thank you, everybody.
Hi, everyone. Just wanted to say thank you for coming to today's event, and also wanted to remind you that our next event will be sometime in September. The date is to be determined, but we will have our jails decarceration team here at Vera selecting a speaker, having a presentation just like this and sharing their thoughts. And for anyone at Vera, you'll see the updates coming through Vera Post, and anyone outside of Vera, you can look to our website and look for the section about the research speaker series. So thank you all for coming, and thank you again to our speakers who are amazing, and have a great rest of your day.
Thank you, everybody.
Thank you.